Hello friends, Nick Maloof here with Maloof Law Group. I am here to talk to you today about the Corporate Transparency Act. It is all the buzz in the business world because it has such far-reaching implications, and it is an important law that you should know, especially if you are a business owner. It really is an important one to keep track of, as you'll see toward the end of this video in regard to the penalties. They are huge, they are significant, and it is important that you take the simple steps to comply if in fact your business is one that is subject to this new law called the Corporate Transparency Act. It was adopted back in 2021. It became fully effective as of January 1, 2024. Its purpose is to fight tax fraud, money laundering, and the routing of funds toward illicit activities like terrorism and other things of that sort. So it has a noble purpose, right? But the problem is it is very far-reaching, and maybe that makes it more effective, but it also makes it easy to somehow not comply with or not be aware of or not be fully in tune with, so that you can get yourself in trouble. So that's what the purpose of this video is, to talk to you a little bit about that as a business owner. Generally speaking, the applicability of the Corporate Transparency Act is a two-step process. Is the company that you are involved with a reporting company? And if so, who then are the beneficial owners? So we'll talk about each of those in turn and discuss whether your company perhaps is something subject to the Corporate Transparency Act. Now, before I get into those details, please understand, I am an attorney and I do business law. And I have many clients to whom I will be counseling in regard to this particular issue. However, I'm not necessarily your attorney if you're just watching this video. And if I am, give me a call please so we can have a specific conversation about your situation. If I'm not, you can still give me a call and I'd be happy to help. But please understand, this is general advice and can't be taken exactly in and of itself as being specific legal advice for your situation. So getting into it, what is a reporting company? A reporting company is any company formed under U.S. law and either a corporation, an LLC, or filed through a Secretary of State of any given state of the Union. So that's essentially what a reporting company consists of. It's a U.S. company that is a corporation or LLC or otherwise established through the filing of a document in the Secretary of State's office of a given state or the equivalent. Some foreign companies are also reporting companies, and those are reporting companies that are foreign in their basis but have been registered here in the United States to do business here in the United States. There are many exceptions to what constitutes a reporting company, 23 of them in fact. But we'll focus on three, one in some depth. The big ones that are most likely going to be exceptions for most clients of mine at least are an inactive entity, which for some reason there's an entity that's kind of lying in wait but isn't otherwise doing anything, a tax-exempt entity, because I represent several nonprofits, and also a large operating company. And a large operating company, there's some things to unpack to determine whether that is something that applies to you in regard to that, making your business an exemption. Of the other, what would it be, 20 other exemptions, most of them are financially related or insurance related, banks for instance, and a variety of other specific types of businesses that for the most part the average small business owner is not going to have an involvement with, at least not as an owner or a director. So let's look at large operating companies. So this again is one of the exceptions to the reporting company threshold, which is the first step in determining whether the Corporate Transparency Act applies to you or to your business. A large operating company is exempt if all of a variety of criteria are met, and they list them as being 6, but they really overlap quite a bit. Essentially, the exceptions that define a large operating company are companies that have more than 20 full-time employees. Those 20 full-time employees are working here in the U.S. There is a presence, physical presence, address and such, or operational facility located in the United States, and tax returns indicate that more than $5 million in gross revenues are received from U.S. operations. So if there are foreign operations, those numbers don't count. U.S. operations are in excess of 5 million, more than 20 employees, all of them, at least 20 based here in the United States, and there being a physical presence. That constitutes a large operating company and an exception. From a policy perspective, I don't know why the exception is so sweeping, because there are a lot of companies that meet these criteria that for the most part, wouldn't be considered that large in the big scheme of things. They're certainly not public companies if they only have 5 million in revenues and 20 employees. But nonetheless, that's what the threshold exemption is for large operating companies. So then the second step in determining whether a given business is subject to the Corporate Transparency Act is whether, who exactly are the beneficial owners. Because once you are a reporting company, you've got to report. Then the question is, well, what do you report? You report according to whoever the beneficial owners are, because the intention of the law is to determine who's getting the benefit of the company and ensuring, hopefully, or in theory, that the benefit isn't accruing to those who it shouldn't accrue to. Some type of illicit activity or the facilitation of money laundering, that sort of a thing. So a beneficial owner is any individual who directly or indirectly has either substantial control or 25% ownership or more in the entity. So there are several exceptions. If the child happens to own, if there's certain agency relationships, but the key exception that most businesses have to think about are for employees. There may be a big enough company where there's an employee who really kind of runs the show. Maybe a few of them, maybe a selection of them. And so then the question is, are those people beneficial owners under the law? And the question is, they can be beneficial owners of the law, but the exception only applies if they are an individual who is an employee, truly an employee, not an independent contractor, whose benefits from the company are exclusively related to his or her employment. So the employment is the key for that person to receive whatever benefit they get. It's a bargain for exchange. The company controls the employee under employer law. The employee does what the company says or what is required of them. And so that relationship is there in both directions. And then finally, that employee, though having a lot of control, does not hold an officer position in the company, CEO, CFO, general counsel, or any number of others where there is a formal title there. If they do have that title, then they're no longer exempted from becoming a beneficial owner. They actually do have to report as being a beneficial owner. And so then, there's another form of beneficial owner that is really a company applicant. Sometimes businesses own businesses, and that chain has to be followed through to figure out who the individuals who really is benefiting ultimately from the ownership structure, whatever it is, even if a business owns a business. That's a little bit beyond the scope of the conversation today. If that's something that you're facing or that you have a company that owns a company, we can certainly discuss, but generally speaking, that detail just follows all the way down to the individuals who are actually behind, ultimately, the companies that are in charge. And so then the question is, well, if you are a reporting company, and if you do therefore have to disclose who the beneficial owners are, whether those be individuals or other companies, how do you file, when do you file? Well, if the entity that you are a part of has been in existence prior to January 1 of 2024, you have to file within calendar year 2024. If it has been established in 2024, in the last month and a half or so, it's mid-February when this video is being taken right now, if it's been established in 2024, then you have essentially 90 days from the time of its establishment, which presumably means getting articles of organization, articles of incorporation, or some other acknowledgement from the Secretary of State's office, whatever state you happen to be in, that the entity has been approved. You've got 90 days from that point, and it's calendar days, it specifies calendar days, to go ahead and file. If you establish an entity after January 1 of 2025, thereafter, any reporting company has to file within 30 days of that company's establishment and report who the beneficial owners are. So interesting, if it's pre-existing prior to January 1 of this year, 2024, you've got all of calendar year 2024. If it's established in 2024, you've got 90 days, calendar days. And if it's January 1, 2025 or later, then you've got 30 days to go ahead and get your filing in. So how is it that you file? And moreover, what is it that you file? So the filing itself is an online filing. It's actually pretty simple. You probably don't need an attorney necessarily to do the filing for you, although that may be your prerogative in terms of whether having me or some other counsel help you with that. You go to a certain website that is a public website. It's called the Financial Crimes Enforcement Network website to self-report. And I will attempt to put a link below in regard to how to get there. And once you're there, you identify the reporting company, and you ultimately identify those who have beneficial ownership. And with that, you're done. And presumably it's a sort of one and done thing. There's no fee to do it. If things change, then you have to report them. It's akin to a statement of information, which we have here in California. But I mean, it's as simple as that. It does, however, the one wrinkle that you might need to know in advance before trying to comply and report is that it requires an image of certain identifying information of those who are beneficial owners. That image could be a copy of their driver's license or a copy of their passport. So it's not just the fact that they have a license and the number is such and such and their license is from such and such state. It's also an image of that license, which is something that you might not know to do unless you know to do it, and be prepared and make sure that you're ready to go. So I alluded to this in the beginning, and it's really an important factor. You know, I think those that put together this law anticipated that it would be too easy to ignore, and yet from their perspective it was too important for the law to be in place. So what did they do? They created a gigantic penalty for those who don't comply. And that, I believe, is going to catch some people. There are going to be some innocent people, innocent companies that are going to be caught in the middle of this and cause some trouble. The penalties are expensive. They're $500 a day, and willful noncompliance will incur up to a penalty of $10,000 and even 2 years of jail time. So we don't know what happens to those who legitimately say they forgot. It wasn't willful, they just forgot. Arguably that's negligence, but that's far from willfulness. Or they're just trying to run a business and they're busy, and also they essentially forgot or just didn't get around to it. So please, if you think that you have this type of the type of entity that would be applicable to the Corporate Transparency Act, it is very much worth your while to figure out whether you do have one that's applicable to the Corporate Transparency Act, and to go ahead and file. This year, calendar year 2024, unless you just established a company in the last few days, you know, which is within 2024, you got all year to do it, but you might as well get on it quickly. So in conclusion, I think the law is, you know, it's a good purpose. I mean, nobody wants to see rampant misuse of funds, embezzlement, money laundering, terrorism, those kinds of things. I mean, those are all bad things. We understand that. But I do think the law is misguided, and but that doesn't really matter in terms of whether you need to comply with it or not. You just have to comply, because as we discussed, the penalties are pretty stiff. So please, give it some thought, work with counsel if necessary, make sure you comply if it is applicable to you or to your business, and make sure that you steer clear of any of these heavy penalties. Again, I'm Nick Maloof with Maloof Law Group. Thank you so much for watching. I appreciate it. If you have any questions, please give me a call. Thanks so much. Have a great day.